Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. Brokers and designated brokers, do you ever give instructions to Escrow to pay a third party from Escrow before the commission check is cut to the firm? For example, from Escrow, pay the stager, or pay an inspector, or pay a contractor, or pick your favorite third party. Are you aware of a scenario where a broker or a designated broker ever instructs Escrow to pay a third party from the proceeds from the firm's commission before the commission is paid to the firm? I suspect you are. Second question I would ask is, why? Why are you doing that? Why are you asking Escrow to cut a check directly to a stager rather than having the compensation paid to the firm and then the firm sharing compensation with the broker and then having the broker write a check to the stager? If the answer to your question is, we want to save the B&O tax on all of those third-party fees that we're paying, we want to have our commission check by the time it comes to our firm be less the amount that we have to pay to all of those third-party providers, so that when we pay tax on the commission we earn, it's a smaller check. Designated brokers, it's not working. And this is an issue we covered, I don't know, I thought it was more recently that we'd covered it, but I've talked to some brokers recently, designated brokers, who are good designated brokers, who know the rules, and they're not familiar with the fact that your firm owes compensation on the entirety of the listing compensation the seller agreed to pay from the beginning, even if you take part of that commission check and pay third parties. And it doesn't matter whether you're the listing firm or the selling firm. Let's say that the seller agreed to pay listing compensation to the selling firm in the amount of X, and agreed in that listing contract that half of X, which is represented by Y, will be paid to the selling office. The Department of Revenue's guidelines are clear. The firms are liable for B&O tax on the amount of, well, for the listing firm, X minus Y, and for the selling office firm, for the amount of Y. Those are both going to come out to the same amount because it was a 50-50 split. And each firm is going to be responsible for that amount. What if, from the listing commission, the listing broker has agreed to pay a stager and an inspector? Let's just say that. And so the listing commission is reduced by those amounts before the check gets cut to the listing firm. And let's say on the buyer broker side, on the selling office side, that the buyer broker has agreed to pay $1,000 of the buyer's closing costs. And so that amount obviously comes off of the commission, off of Y, before the check is cut to the buyer broker's firm. In both of those scenarios, what dollar amount is each firm required to pay B&O tax on? And in both scenarios, each firm is required to pay B&O tax against the income of Y. Reducing that income by paying third parties before the check comes to the commission, before the check comes to the firm, or reducing that amount by paying concessions to one of the parties. All of that's irrelevant. The amount of compensation agreed by the seller to pay at the time of the listing, even if the listing broker is the one who paid concessions back to the seller themselves. So the seller ends up paying a smaller amount of compensation because the listing broker gave a concession back to the seller. That originally agreed amount of compensation from the seller and that the listing broker agrees to share with the selling office firm, those are the amounts against which the firms have to pay B&O. Even if those amounts are reduced before the check is finally cut to the firm. If you think that you're avoiding the payment of B&O and writing a smaller check for B&O because you think you're saving money by doing that, you're probably creating a tax liability problem for yourself. You need to get in touch with your accountant and you need to get this straightened out. So brokers, designated brokers, there's nothing wrong with paying a third-party provider directly from escrow, assuming that the payment to the third-party provider is not contingent on a successful closing. So let's say that you're going to pay a stager, you're going to pay the stager whether we have a successful closing or not. Fine. Let's say you're going to pay an inspector and you're going to pay the inspector whether we have a successful closing or not. You're paying the inspector or the stager from closing merely as a convenience so that you don't have to get the commission and then write a check yourself. You're going to let the escrow company write the check. If that's a true statement, and if you've got a contract with that stager or that inspector making clear that you owe them compensation whether there's a successful closing or not, then there's no problem, designated brokers, with you giving written instruction to escrow to pay those third parties directly from escrow. But if payment to that third party is conditioned on a successful closing, then designated brokers, you can't pay them from the commission check, from escrow, because that would violate the license law restrictions against you sharing compensation with anybody other than another licensed real estate firm. If you've earned your compensation and you simply ask escrow as a convenience to write a check to a third party, fine. But you can't share your earned compensation with somebody else other than another licensed real estate firm or a broker licensed to your firm. And no matter how you pay those third parties or give concessions back to a client, you are still liable for B&O on that amount of compensation earned by your firm. If you have questions on this topic or any other, send an email to me. But if you've got tax questions, loop your accountant in, because I've now shared everything I know with you about tax law. Thank you for being a Washington REALTORS member.